Nebraska Rule of Appellate Procedure 214D1. Citation of unpublished decisions. Citation of unpublished decisions in briefs and oral arguments is freely permitted for purposes of establishing res judicata estoppel or the law of the case. Citation of unpublished decisions or other purposes is not encouraged. And you should remember that today when you're listening to Unpublished Opinions. This is our third episode. This is a short circuit podcast. We are recording it on a Friday, November 3rd, 2023. But as you will know from our first couple episodes, this is not short circuit itself, but our own different podcast where we talk about other stuff. Joining me today to talk about other stuff in the legal universe are a couple Institute for Justice attorneys, familiar voices to our listeners, Patrick Jaicomo, returning to Unpublished Opinions, and for the first time on the new show, Sam Gedge. Welcome, gentlemen.
Oh, thank you.
Thank you, Anthony.
Thank you.
So, Sam, you have some thoughts on the publication, they're very much not unpublished, publication of people's titles.
I guess that's right, Anthony. Or maybe not. I don't want to change the rules midstream, but I think
there are no rules.
There's no
Sam.
stream. We're just getting started. You can just
Okay. All right. Well, let me dive in on the thing that I was thinking about, which was the growing practice of referring to certain litigants, certain attorneys before the U.S. Supreme Court as generals, general so-and-so. So we can kind of talk about that. I thought it might be useful to talk about the grammar of it for about 15 seconds, right? Because the Solicitor General, for example, of the United States, currently Elizabeth Prelogar, for the past maybe 20, 30 years or more, when the Solicitor General of the United States has stood up at the lectern to argue at the Supreme Court, typically they have been referred to as General so-and-so, General Kagan, General Verrilli, General Prelogar. I did about 20 minutes of research on this morning, Anthony. And
pulling out all the stops for the podcast. I appreciate it.
This is unpublished, so I think this is just a conversation between the three of us. But according to Garner's Modern American English, this practice was popularized, he thinks, by Chief Justice Rehnquist at some point or other. And now just most of the justices certainly seem to refer to the federal Solicitor General as General. And in fact, if you go to the transcripts, instead of saying Ms. Prelogar, every time she talks, it's General Prelogar. So I promised a bit of grammar, Anthony, so I don't want to leave you hanging on that. So grammatically, this is something I think of a barbarism. The general in Solicitor General and Attorney General is what's called a postpositive adjective. It's not kind of like the title itself. The title is solicitor. Title is attorney. The general is basically an adjective modifying that title. So in the same way that you have a notary public, or you have a court martial, or a controller general, or a professor emeritus, the last word there is just kind of a adjective modifying the title itself. And so just as we don't go around calling notaries public, Public Smith, we call them, if anything, Notary Smith or Mr. Smith. It's equally grammatically flawed to go around calling Solicitor General, General Smith or General Prelogar. I'm happy to kind of keep going on this, but
I love this discussion. Before we get into it, I also want to tell the audience, if you don't know, the Solicitor General and everyone in her office gets to wear this fancy little jacket when they go before the Supreme Court too. That's extra long. It's kind of like a piano maestro who has to sit down and flip their jacket out. So that's just a little fun fact if you're not aware of it. But I do
But other advocates wear those too, right? They're allowed to wear those. It's just most don't go to the tailor and pay an extra $2,000 to get one.
I think you would probably look like you're trying to impersonate a member of the SG's office if you did that. That's my theory.
Your jacket's too long, sir. You are under arrest now. I actually don't know. I mean, I'm sure obviously the court has a dress code, but some of the circuits across the country have much more rigorous dress codes and for instance, specify you have to wear a suit in this particular color or two. But I don't know if anyone's actually talking about with enough specificity, like the length of your jacket or something silly like that. Like if you went in there wearing like a horsehair wig, I mean, I don't know if they would comment on it, but I doubt it actually breaks some sort of rule.
I vaguely remember reading this article. I think this was in England, where some lawyer gentleman just like was showing up just wearing like a homemade wig and like a ermine red robe, which I guess is poor form as a lawyer, and he got in some trouble about that.
Well,
but it's a different.
It's interesting because I've been into some of the courts in the United Kingdom and Ireland, and they still maintain the wig thing. But now it's just like a hat. And so you'll see like a 24-year-old woman with a ponytail who just like slaps a wig on top of her head and does the argument in the court and then takes the thing off. And of course they've got like little robes and stuff too. I feel like we in America, we don't have the sort of pageantry that most other Commonwealth countries' lawyers get to engage in.
I think that's right. I mean, because the Maryland Supreme Court, which has the red robes, and I think everyone, if they think about it at all, thinks, oh, this is a throwback to like the 1680s when whatever Maryland first became a colony, maybe, I don't know. But I think someone told me that in fact they switched to red robes in like 1970, so it's actually a pretty modern innovation. Really? Yeah,
Supreme Court of Canada still has red robes.
Yeah, and they've got like the big puffy white fur lining too, I think, on them. So they've even out flexed the Maryland Supreme Court, which is now called the Maryland Supreme Court.
Indeed it is.
Yeah, it took a little time. New York still has some work to do on that. Oh my
goodness.
The New York courts.
Well, it's frustrating because when you talk about it, even if you understand the nomenclature, you still have to specify for anyone you're speaking with, because even people who are familiar with New York are going to revert back and forth between the Supreme Court being the highest court in the land, which it is everywhere, I think, outside of New York and a couple other places, and being the lowest, which it is in New York itself.
Right. Because, I mean, you still have the West Virginia, the Supreme Court of Appeals. They might have changed that, too, in recent years, though. And then you have the Supreme Judicial Court in Maine and in Massachusetts.
Yeah, I mean, it seemed to me that it was always fine if it was called the Supreme Court of blah, 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 because then it's like a kind of back to our original conversation. You're saying, well, you're still calling it the Supreme Court. The rest is just adjectives you're adding to make it seem fancier, I guess. But you understand the concept.
Right. I mean, New York's problem isn't so much their highest court is called the Court of Appeals. It's that their lowest court is called the Supreme Court.
That's right. That's exactly right. But back to the point, I do, it's funny to say like, well, we could call them solicitor instead of general, for instance, if we wanted to use this title. But then I'm imagining applying that to like the attorney general. And so you're just calling them attorney at all the press conferences.
I think that's right. I mean, I think if you were really concerned about it, you would just call them like, Mr. Attorney General or Mr. Solicitor General or Ms. Solicitor General. And in fact, I think like I read this, there's this one law review article on this. It's by a law professor named Michael Hertz. And Anthony, if you have show notes, you should put a link to this excellent article in those show notes. And he says that there's like, there's books out there about how you honorifics, and apparently the standard practice in the honorifics books is to refer to them not as general, but as Solicitor General or as Attorney General in full. I don't know. I mean, I think the obvious reaction to this is that it's just a bunch of grammatical pedantry and who really cares. In fact, I was listening. Solicitor General Preligar was on NPR about a month ago, as you may know. It was delightful, and they asked her kind of what should we call you, and she acknowledged the whole post-positive adjective problem with calling her general, but then basically said, yeah, like that's kind of for grammar nerds, and I kind of like being called a general because, in fairness, like who wouldn't like being called a general?
But I think there is something to this though, in that hearkening back to our when we were talking about pageantry, calling someone general. It's not just like calling someone, I don't know, some other run-of-the-mill title, right? A general, the real generals, that's a pretty big deal, right? To be a general. So calling the attorney general general seems like it's a way of trying to put some extra honorifics on that office, that maybe Chief Justice Rehnquist didn't intend to do that, but it seems like it happened, because if you're meeting someone, you're saying general because of what a actual general is, that's going to carry a lot more weight than like, oh, I'm supposed to address them as sir.
Well, there's
whatever the heck
there's a ton to unpack there, and I guess I would start by saying, one, to be fair, there are a lot more military generals than there are solicitors general of the United States. There's only one of those at a time.
So use the whole title.
The other thing, though, is
special.
And I haven't looked into this in forever, but this comes up every once in a while in the discussion of like the title of doctor and who can use it. But my understanding is that the title of military general actually was originally something like captain general, and then that got shortened to general. And so like all of this, to Sam's other point, or to General Preligar's other point, is, well, this is just, sophistry. Essentially, these are just all accidents of history. And so it's kind of like the evolution of language. And if Chief Justice Rehnquist, who we would all think someone behind the scenes would just call chief, even though that's the adjective to the noun justice, caused this to happen in the United States, then, that's the same way that at some point in history, Captain General just became general. And now we all think, well, you're essentially stealing valor by calling the Attorney General general.
Yeah, maybe that's right. I mean, I think there's a point to that, the Captain General thing. I think if you like technically go to this U.S. code at this point, like the title of general is just like general. So, but I don't know. I mean, I take Anthony's point about the militarization, right? Like, obviously, language can evolve, but it's worth asking whether this is a good evolution or a bad one. And I think, like, the Professor Hertz's article focuses, I think, on the kind of weird militarizing of these, like, quintessentially civil and legal officials. Like, I don't know that we should be super jazzed about that. And he posited that it became a bit more popular kind of right after 9/11, when I guess there was just people wanted to be more militarized for understandable reasons, and the title is just stuck to a degree. I don't know, like my quarrel with it is less kind of like the grammar pedantry and less with the militarization, and more honestly with just like the kind of appearance of the government's lawyers at the Supreme Court kind of having some kind of special stature, right? In that, I'm preaching to the choir here, I know, but right, like the federal government in particular, like they have a ton of power. And most of the time when they're at the Supreme Court, they're like trying to put people in prison for decades at a time, or like, all these other exercises of really formidable authority. They have all sorts of litigation advantages at every turn in most cases. And I don't know, it just strikes me as a little bit questionable that, like, on top of all of those kind of substantive advantages they have, like, now when they get up to the lectern and they're kind of given this barely grammatical title that like sets them apart from all the other attorneys who are up there also representing clients. I don't know. It seems like a little bit in tension with the general kind of equal justice under law vibe that, is carved into the building itself. But yeah.
No, I think that's true, but I actually, it could cut both ways. You could say, well, at least they're being honest and open about the fact that they're putting a thumb on the figurative and literal scale of justice here because this person represents the power of a state or the federal government. I do think on the militarization point, if we're going to talk about that at all, we really need to talk about the wackiest example, which is that the Surgeon General wears a military uniform.
Let me quickly jump in
Please.
On that, Patrick, because I did a lot of research on this too this morning. The Surgeon General does wear a military uniform, but not because of the postpositive adjective general, but because by statute, the Surgeon General must be an admiral or like a vice admiral or something like that. So they actually do have some kind of military rank, and it's not the general.
Then why don't we call him the Surgeon Admiral?
Well, I mean, I think you could, or Dr. Surgeon Admiral, I think, would be his I don't know. But I mean, that just kind of proves the point, right? Like I think at this point, a lot of folks are comfortable calling like the Attorney General or the Solicitor General because they seem like they're just kind of like a big deal. But why aren't we calling notaries like Public Smith? Like why aren't we calling like the Inspector General of the Government Publications Office like General Bob, yeah. Right? I don't know. It just strikes me as a little bit.
It does feel like it kind of goes around the bend once you start adding even more honorifics to it, and it's like the people whose professions are those that sort of collect the series of letters after their name, and so it'll be Patrick Jones, CRT, TDD, MSSA certified. And you're like, what in the world? Like, this isn't even communicating anything anymore, and it just looks at that point like you're a North Korean general, and the entire left breast of your jacket is covered in medals that obviously you couldn't have possibly won.
Well, you never know. Maybe they earned them all. The one other thing, can I quickly kind of take us to the one thing that sprang to my mind as I was giving my 20 minutes of research to this afternoon, which is how does all of this interact with the proliferation of state solicitors general over the past 20 years, right? Like, it would seem weird if we only call the federal solicitor general a solicitor or general, but we don't call the state solicitors general also general, right? Like, we care a lot about federalism, and it would seem like a weird thumb on the scale against state government lawyers. And the answer, based on my 20 minutes of research, is that it's just a complete chaos. So I went back through like the past couple of years worth of oral argument transcripts where there was like a state solicitor general representing, and It's just like sometimes they're, Mr. Fisher, the former Indiana Solicitor General. Sometimes he's General Fisher. It just is completely all over the map. The one consistent state Solicitor General who gets called General seems to be General Stone, until recently the Texas Solicitor General. But for the other folks, like the West Virginia Solicitor General, Lindsay C., she has only been Ms. C., not General C. It's completely incoherent, which makes me just wonder, like, one, is like the court staff asking these folks beforehand, like, do you want to be called general or do you want to be called like an ordinary title like the rest of us? Or if they're just, I don't
No, I do wonder if that's a question that's asked, because before oral argument, you get a form to fill out and they ask you to spell your name phonetically. And so maybe they're asking the government titled litigants, what would you like to be called? The proliferation of SGs thing is interesting because, presumably even before many of these states had a formal solicitor general, all these people that would be representing the state were still attorneys general. And so they would have been equally susceptible to being called general. But of course, then me saying that out loud, to the point you made right at the beginning, Sam, is we have been taught that the proper thing to say is attorneys general or solicitors general. And still, when we refer to the person through this sort of, we don't know, maybe made up, maybe the new actual correct honorific, we're calling them the adjective, the second thing, the general.
Well, I think whether they're asking to be called that on the form or whether this is what the judges in various courts are just winging it and calling them, I think that's an example of a linguistic rule that is perhaps emerging, but is definitely not yet settled yet. And it's kind of just, a snapshot in action, which is kind of neat, of the culture trying to work itself out, how it's going to use this. And it seems like we haven't settled. I mean, I guess they have at the U.S. Supreme Court, but generally the language has not settled on what the actual title should be. One thing that was settled that you mentioned beforehand, Sam, but we don't do anymore, so maybe this is the flip side, is the Mr. Justice so-and-so, right? So what is it that they used to always do that, and did that end like when O'Connor came on the court, because then they started to have Mrs. Justice, and this is just too much, and they just dropped the whole thing, or like what happened there?
I think that's right. So I wasn't able to pack that into my 20 minutes of research for today's podcast, but I think I've run
5
across,
minutes later.
We should have. I could pause right now, but I vaguely remember reading somewhere once that it was when Justice O'Connor joined the bench, they just kind of decided to cut it off. Though of course we still have that vestige with kind of like Mr. Chief Justice and may it please.
But and they didn't just say that at argument; it would say it in the opinions.
Yeah,
like Mr. Justice Black joins, this portion of the opinion.
Yeah. Well, and they would also do like they would use brother a lot more often, right? Like that would be in the opinions too. I think brother so and so.
Like, I don't get what was going on there. The Mr. You already got justice. Like every male person is a Mr. Why are you throwing Mr. on?
I don't. It's like
there must be some weird origin.
Yeah,
story.
I mean, there's got to be some explanation that goes back to like the way that the British do it, where you say like Lord Chief Justice or so and so. I mean, I guess I don't know. Was there ever some fancy old Chief Justice in England who wasn't a lord? Or is that like, it's like you have to get your lordship and then it's part of the deal?
Well, yeah, I think they're all, I mean, that's been a long time. I think that English judges have been lords. They're not lords as in lords in the House of Lords. They're law lords. Well, then there's the Lord Chancellor, who is a judge, but also a lord.
Is he a judge in the courts of equity, Anthony? The courts of chancery?
Well, so he was the judge in the court of chancery, in chancery, until they started getting vice chancellors in like the mid 1800s, because they got Lord Elgin was there for like 30 years, and like everyone got tired of him. So when he died, there's all this reform. In fact, a lot of Victorian reforms you can date from the death of Lord Elgin.
Is he of Elgin Marble's fame or no? Is that a foolish question?
I'm pretty sure. You know what? That's a great. I don't know if they're related. I think I should do a little bit of live research.
Yeah, go ahead
and answer that.
Go ahead. And in the meantime, I'll just say that I believe the fanciest line of watches from the now defunct Elgin Watch Company from Elgin, Illinois, was called the Lord Elgin series. So he got. I suspect that Elgin, Illinois, was named after him to begin with. But then it got even more specific once those wristwatches became the hot commodity.
I've also heard it pronounced Elgin in like the Elgin marbles context, but I don't know which is correct. Elgin feels right, but
there could be a dispute there. I we could bring one of the Elgin family on.
Great idea.
Do you have that kind of power?
I sadly lack it. And my title does not give me that power. It looks like, well, definitely they were not the same person because they lived at slightly different times. But maybe one, they must have been. Maybe they were different Earls of Elgin. Yeah. Another point on this is the use of titles. Now this gets a little controversial. Friends of ours use this, so we don't want to go too deep. I'm just going to note, I've been public about this in the past. I think it's a little odd that once someone gets a title, especially a public title, that, a title that like goes away when you're stop being that thing, that everyone just uses it for like the rest of their lives.
Agreed.
Is that a worry? Maybe it's just nice.
What is the protocol?
What's the harm?
What is the protocol for people that have that set up, but they don't? It's not immediately clear which of several titles they have had in their career that is the highest. And so you could be like, Chief Justice Taft or President Taft. You just go with the most recent one. Or if you were like a federal senator, but then you were also some other fancy thing. Or maybe you were a military official and then you became a member of the House of Representatives. And so I don't think there's actually rules. Maybe there's some sort of like Emily Post book that tells you which one of these you're supposed to use in which setting and maybe not. I can't imagine this entire conversation. There's somebody who's listening to this and an absolute expert on this subject. And it's like the old commercial for milk where the guy's trying to call in and say that Alexander Burr is the one who shot, or Aaron Burr is the one who shot Alexander Hamilton, but he has a mouthful of peanut butter sandwich. And they're just like screaming at their podcast.
Well, if you do have the answer, please write in. We'd love to hear from listeners.
But no, I share what maybe your discomfort with it, Anthony. I mean, because there's like, this isn't a perfect analogy, but there is something in the Constitution about how like titles of nobility, you're not supposed to kind of get to have those. And obviously this would not be a title of nobility technically, but it feels like it kind of rhymes with it, right? Like these titles are not your property.
This is the spirit. That's certainly the spirit of the prohibition on titles of nobility. It's like, you don't have, it doesn't come with like land or power, but the concept was, I think, we want everyone to be viewed equally in the eyes of this democratic process that we've created through the Constitution.
Yeah. I mean, I don't think there's a lot of harm in it, but especially if it's in a setting, So I always, unless I know otherwise, if I meet a former judge or justice, which I do on occasion, I will try and remember to call them judge or justice. Unless they let it be known, like, call me Dave. Many lawyers are listening to this position. So you maybe when you have an appeal, you get some extra help. And you might hire someone who used to be a judge, especially because they could help you with that court. They were a judge there. And in that setting, I have usually called that person like their first name because it's like, we're hiring you. You're working on the team with me. We want to get to know each other. I'm not going to say judge this, judge that. I mean, if they were to say, call me judge, I would call him judge. But if I just meet someone on the street, I will try and use the former title. But I mean, it seems like most people do that. But sometimes I think it could get a little weird, especially if like you were an ambassador for 2 years, 40 years ago. And like people, you would always call Alan Keyes, the Honorable Alan Keyes, even though I think he was, what was he ambassador to? It was a not that huge a deal, I think, that he was ambassador.
Well, he might beg to differ.
Yeah, how dare you? I mean, then I love the thought that you're then like, okay, well, which country were you the ambassador to? Because that will determine whether you were honorable or not.
Oh, I'm sorry. Well, he was ambassador to the United Nations Economic and Social Council.
Okay.
Well, now you've insulted the council as well, Anthony.
Well, we don't want to insult, UN groups, especially those, headed by the Islamic Republic of Iran or anything like that. No one wants to pick up on that. So
I already said, how dare you once.
I wanted to point out to the listeners, if you're into this subject, there is this amazing essay by Mark Twain called "Does the Race of Man Love a Lord?", where he talks about the tendency of people who used to have titles to continue using their titles. And it's a good, it's classic Twain stuff. But I thought I'd read just a line here. He says, "I have been personally acquainted with over 84,000 persons who, at one time or another in their lives, have served for a year or two on the staffs of our multitudinous governors, and through that fatality have been generals temporarily, and colonels temporarily, and judge advocates temporarily. But I have known only 9 among them who could be hired to let the title go when it ceased to be legitimate." And then he goes on and like legislators, all that kind of thing.
Well, can't argue with that. Can I say one more thing on this, which is a little bit off topic. But I feel like if you go back to like P.G. Wodehouse books, right, 20s and 30s, just like everybody got to be an honorable back then, right? You have like the Honorable Barney Fungi Phipps, and like they didn't actually have any positions. If you were just kind of like a gentleman of ledger, you got to be called honorable. So I feel like it's kind of like we're kind of in the worst of all worlds right now. Like if we're going to do this, like let us all be honorables. We can just kind of throw that on our name. And if we're not, then maybe we should all just not have these titles.
Here. And I was going to say, and I'm going to let this go now without us ever delving into what the heck a Kentucky colonel is. But I actually know a real life Kentucky colonel. Shout out to Mark Pendry. I have no idea what that means, and I don't know what it has to do with Kentucky Fried Chicken, but the things are related.
So that is actually more than just what Sam was talking about, where you call, a distinguished gentleman
Yeah,
colonel,
you get to become a Kentucky colonel, and I only know this because Mark had the thing framed on his wall. You get like a state commission from the state of Kentucky that makes you a colonel for something. I don't know what you're a colonel of.
Do you have like an obligation to kind of join the militia if there's any civil unrest, or is it all upsides or are there downsides?
I don't know. I like to think that they can call back all the Kentucky colonels in the whole world if, in times of true necessity.
With great power comes great responsibility.
Yes, like some sort of Avengers Endgame scenario where all the Kentucky colonels just show up out of a bunch of warp holes.
Well, I think, Sam, what you're putting your finger on also is, maybe I'm just thinking of this because I'm reading one of Gordon Wood's old books right now, but that kind of goes back to the distinction between commoners and the gentry. And so if you're a member of the gentry, you have some kind of title, even if it's just gentleman, right? You wouldn't call any man gentleman, but you call the upper crust, even if they're not aristocracy, strictly speaking. And so you'd call them gentlemen or like esquire. Right, esquire.
The most important of all.
Like I have an ancestor that I've tried to figure out. He was like my great to the 5th grandfather. I've tried to figure out what his occupation was. I don't think it was all that weighty. And it is the one like notation we have is just says esquire. So
sounds like a good life.
I don't think he was independently wealthy, but it's hard to tell. My finally, I'll say, a lot of people probably have this in their family background. My grandfather and his old generation who grew up in England called their father governor. So everyone just referred to him as governor, or all the kids did. And that was like kind of normal.
That strikes me as historically sound.
Yeah. So,
I mean, you always like imagine, like, sorry, I cut you off, but like in Sherlock Holmes books, like the taxi driver is always calling his customer like governor.
Yeah.
As well. I wonder if that's
and like, kids used to have governesses back then too. So I suspect that that's the flip side of it.
Right. Well, that turns to history. So I don't think we have that much time to delve into these issues. I just want to scratch the surface. We could make this like a 3-hour episode or more. We could make a podcast series. But I'm a little confused on the whole, and maybe this is just what happens when you get a new court or you get a movement that has matured in some way, and so people try to figure it out and they go overboard. But I'm a little overwhelmed and confused by all the history and tradition talk in constitutional law these days. And I don't want to denigrate the use of history and tradition because I think it's often very important. I don't even want to denigrate like using originalism, and we could have a whole originalism debate, I know. But seems like people either in court, maybe not judges themselves, but advocates or writers, scholars are going into history and tradition in ways that don't make a lot of sense. Like you don't need to go to the history to see what like this totally ordinary word means.
Yeah, that's been my
that was adopted recently.
That's been my biggest frustration is like the fact that it's supplanting plain text. And, if the language says what the language says, of course, if words come to mean different things over the course of centuries, okay, then we can talk about that. But when everyone agrees that these are what these words say and these are what these words mean, and then ultimately the result is, but we found some historical justification for departing from what that meaning was, that seems frustrating for a couple reasons, but the chief among them is I think that a lot of the same people who would, I think, rightly argue that the text of modern statute should govern and not the underlying intent of the people who may have been involved in passing, but not obviously passing it themselves because it takes a majority of legislative bodies. We don't accept those arguments today. We wouldn't say, hey, a modern statute that says this but actually means the opposite should be enforced that way. But sometimes we do that with historical provisions, and I don't understand why it would be, why the intent of the old people should matter and the intent of the new people should not.
I mean, that was often a criticism. I don't think it was a super fair criticism, but that was a criticism of Justice Scalia that he would be all, legislative intent is incoherent. We should not use it in our interpretation of statutes. And then when you're talking about the original Constitution, you turn to the Federalist Papers, which is, it's kind of worse than legislative history, right? Because it was actually propaganda in favor of something.
Yeah, no, that's absolutely true. And I also think it's a little bit problematic that the way we look at history and tradition is treated at the end of the day when you read a decision or when you see a party's argument as if it's definitive. And especially what we've seen, recently is a lot more delving into the common law as some sort of guidepost for how to interpret things based on whatever era that we're talking about. And at the end of the day, it often ends up looking like the common law was settled on these matters. And in reality, the common law is rarely settled, except for in the most basic of premises. And so it might be that, 25 states did it one way and 8 did it the other. And that doesn't, to me at least, necessarily mean that the 8 were wrong, let alone that the common law itself is some sort of indication that could have been relied on tacitly by then Congress passing some statute in some era. And so that's the piece of it that always trips me up, is that ultimately what actually ends up happening is, even if you set aside the potential for cherry picking, you have a situation where ultimately wherever the burden is laid by the court on who has to show the common law did or didn't do something, they can lose just because it's up to them to show the common law didn't allow this thing or that the common law did allow this other thing.
Yeah, and then there's the whole question of the distinction. We talked about this on Short Circuit recently with Dan Epps about the distinction between the common law of a state and the general law, and the whole idea of the general law. And when we are talking about like the common law understanding of, say warrants in 1791, are we talking about the general law? Are we talking about federal common law, which could be different than general law? And I guess that just all goes to, we have to be, I don't think that goes to so much, my point about we're getting a little too crazy with history and tradition. I guess that just goes to, that's a point where I think you do need to go to the history, but the history when you're talking about the quote common law can be very complicated.
Well, I'm thinking of this in terms of, for instance, Section 1983, which is talking about constitutional violations and what the court has done.
I thought what you were talking about.
Yeah, thank you, Sam. And what the court has done is said, well, we think the common law is a good guide for these things, even though essentially we're looking at the common law of torts, and Section 1983 is about constitutional violations. And although in the Fourth Amendment context there's a lot of overlap, basically everywhere else there's almost none. And so now we're abstracting from the text of 1983 to the potential meaning of what that text should be to the analogies of very roughly fit common law torts. To which common law are we talking about? The federal common law that was understood at the time, the general law, the state common law, which states, how many states, so on and so forth. And so it almost is one of those situations where, if you find the missing link, then there are just two more missing links on either side of it.
So that's a good point about 1983, which for those not familiar with it was passed by Reconstruction Congress in 1871, hot on the heels of the 14th Amendment, which was fully ratified in 1868. And this gets to actually the original reason for bringing this up, which is you can say in certain doctrines maybe there's reasons that this is sound, but some of the kind of more sloppy constitutional interpretation going on the last couple of years, and I don't necessarily mean the Supreme Court, I just mean in people's analysis, is that, well, a good way of looking at it, if a law is constitutional, is seeing if those laws existed when this part of the Constitution was adopted. And if they were, well, it must have been okay. And of course, Bruin is the big example of this. And Bruin has its own reasons where they're trying to correct what the lower courts were doing. And it's kind of a stick to do that. And maybe they'll trim it back now. So I don't really mean to single out Bruin, but the general idea that, the Reconstruction Congress couldn't either constitutionally or statutorily couldn't have been meaning to disrupt the common law, or couldn't have been meaning to disrupt, I don't know, the black codes that were, close to half the states had at that time. Well, they were just trying to protect the freedoms we had at the time going forward.
Hold me back, Sam. Hold me back. I mean, yeah, look, this is true in a vacuum, what you just said, if you look at the modern language of Section 1983. But it's even crazier now that we have just rediscovered the fact that the original language that was passed by Congress of Section 1983 said that all of these causes of action for constitutional violations exist notwithstanding any state law or customary usage to the contrary. And so obviously, like you said, Congress in the Reconstruction era was aware that if Mississippi or Alabama could simply get around Section 1983 by making it illegal for black people or their supporters to do things, they would have, and in fact did do all those things. And of course, this is something that we see all the time in a bunch of these immunity doctrines where it's like judicial immunity. Well, we need to be able to protect judges and allow them to make independent decisions without fear of consequences. And you're thinking like, wow, I wonder if anyone who was behind the passage of Section 1983 could have even envisioned that a Southern judge in a state court would have done something to violate someone's civil rights in the United States. And then to glom on not just that one, but the next one and the one after that, and then say common law torts and the rest of it. It's just like we've gone completely through the looking glass at this point.
Right. We're first of all, we're accepting what the conditions were at the time as okay, and then we're building all these layers on top of them.
Go ahead, Anthony.
I was just going to say, I think you could say the same about the original Constitution, which sometimes freedom of the press, they were only talking about actual press equipment. Freedom of speech, they're only talking about prior restraint or what have you. I mean, you can make your arguments based on, again, legislative history or whatever it is. But just the fact that existed at the time does not tell us what they are addressing, especially when the text seems to show that, it goes beyond that. Those laws that existed at the time maybe aren't okay anymore. Because when you adopt sometimes this is literally true and sometimes it's just the spirit. When you adopt a constitution or you adopt like major legislation, it is a bit of a revolutionary act. The whole point of having a revolution, right, is getting rid of some of that stuff. So, when a state gets a new constitution, when you have a new state, like, does that mean all the stuff they had in the territory is okay because they wouldn't mean to disrupt it? No. And there seems to be that out there right now. There is a presumption of thinking of constitutions that way, and instead we should think of them more in kind of a revolutionary sense. So that doesn't mean that it's French Revolution every time you get a new state constitution and everything's swept away. But it does mean that maybe shouldn't have that much of a presumption that the laws were okay.
Yeah. I mean, so the one thing I was going to say was I think that's doubly true because at least in the Bill of Rights, like when the framers did want to preserve the status quo, they said so, right? And if you look at the Seventh Amendment, for example, the right to a civil jury trial, it explicitly is trying to, I think it might even use the word preserve, or there's a clear textual signal in there that they're trying to preserve the common law jury trial right as it existed in the late 1780s or 1790s. So for that provision, it's like, okay, sure. Like we look at the text and we see that they're trying to incorporate the status quo. We don't see that a whole lot in the other Bill of Rights protections, though, which maybe means they weren't planning just to sweep up this whole body of pre-existing common law.
The right of trial by jury shall be preserved. You are correct.
So much of the Bill of Rights is framed in that language to say, shall not be infringed, things like that. Like these rights exist, right? The Constitution is protecting rights that in many cases already existed from some form or forms that
they already existed, but maybe they weren't observed.
True.
Right. I think that's the part that people miss. Just because you're protecting a right doesn't mean everyone in practice enjoyed that right at the time. I mean, otherwise, why would we have the 14th Amendment? It's kind of basic, I would think.
But this is nothing new, really. Obviously, as the slaughterhouse cases tell us, like even right after this stuff was passed, you had courts and other actors saying, well, we're just going to minimize this to the greatest extent possible. And I think now in like the daylight of a century or two after the fact, you can see like, well, some of that was done in bad faith. Some of it was done, I think, probably because certain people thought that was what was necessary to save the republic. We see this with a lot of the immunity doctrines too. They always crop up initially in some context where, a state owes some war debt or something might otherwise pull apart an important political collaboration. And so they come up with some doctrine or immunity that makes sure that particular thing is protected. And then 100 years later, we've just built on that scaffolding in the wrong direction for a century.
Well, not to open things up right here at the end, but I definitely got that vibe yesterday when, just for fun, and I take no position on the issue, and neither does the Institute for Justice, I went to the hearing at the Minnesota Supreme Court about the 14th Amendment, Section 3, and whether former President Trump, see what I did there? Former President Trump can be on the ballot. And listeners, if you made it this far, you probably know this whole debate that Professors Bode and Paulson had this article, and now there's all these court cases. And anyway, looming large was this a circuit, or whatever they called circuit courts back then, opinion. Is it Justice Chase, I think, authored it? And it was about a judge, whether he can sit, but he had sworn an oath to the Confederacy. And so it was like, doesn't Section 3 mean, this judge? And Chase is basically like, if we do this, like, there's absolute anarchy throughout the South, so we can't do it. And not to at all talk about the current situation, but like that precedent now, applies to situations where maybe you wouldn't have that anarchy, and yet you have that precedent. And I'm sure a lot of immunity doctrine accretes, in a similar fashion, where it's much more understandable. The first level is much more understandable than what comes after.
Right. I mean, if you think about the Articles of Articles of the Confederacy, or I'm mixing up my historical periods here, but the point is, you can think about all these kind of important moments when the states were not coming together or were going apart, and how things like sovereign immunity being imported into the United States, even though it really doesn't make any sense in the fact that we threw the sovereign off to create the United States, are justified by sort of unstated policy aims that the courts are looking at when they're making these decisions, but not writing into their opinions.
Chisholm versus Georgia, correctly decided. Well, that is just my opinion.
You heard it here first.
Well, thank you, gentlemen. Thank you for listening, everyone. We'll do another one of these sooner or later. But until that time, that's just like your unpublished opinion, man.
I'm gonna do like a gentleman, go and get some hops, get myself a gun, and